Hello and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. We are talking about motions to reopen after deportation proceedings. Now, the way that it works is one reason or another you get or recently received or many years ago received a deportation order. You might be inside the United States, you might be have been outside the United States and entered illegally again. There's all kinds of things that could happen, but sometimes the only way to resolve a situation is to get the deportation order reopened. Because if it's reopened, it means essentially that deportation order does not exist and you're able to go back into court and fight your case. Whether it's even to fight it for voluntary departure so you could leave without a deportation order, or a variety of other means. In this particular case, one big area of motions to reopen are when you never received notice of the actual court date. For example, you moved, or you weren't told of it, or something happened where you didn't know that you were supposed to be in court. And the reality is, once you go to court, or once you're supposed to go to court, if you're not there, the judge waits to the end of the hearing and calls your name out again, and if not, orders a deportation in absentia, and the next thing you know, immigration is at your door, forcibly removing you from the United States for an order which you never knew you could defend against. So, if that's the case, then the motion to reopen can be done on an in absentia hearing for lack of notice, and the way that works is we can immediately file that, and there's a stay of deportation. So, if they have you in handcuffs and are about to walk you on the plane or the bus to get out of the U.S., the second that's filed, by law, they cannot continue with the deportation. So, it's a good tool to use if you know how to do it properly. Now, many times people will have deportation orders for one reason or another based upon advice that was given by prior attorneys that may have been insufficient, incorrect. It may not have had the proper defenses, and so there could be a motion to reopen based upon ineffective assistance of counsel, and that falls under the Lozada requirements, which basically is a procedure to show that there was not effective assistance of counsel, and you can go that way. There's motions to reopen based upon change of law, change of circumstances, and so forth. There's several different ways of doing it. There are other times people who are, for example, aggravated felons based upon their criminal history, and they have a second illegal reentry in the U.S. In that case, there's nothing that can be done except the motion to reopen to then show that there wasn't an illegal departure, basically. So keep in mind these various ways, and motions to reopen are powerful tools under certain circumstances. Okay, more on the coming videos.